Hi, this is Mr. Mullaney. We're going to talk today about Thomas Jefferson, part two, or take two, as Mr. Colin Boyle, my student teacher, says in this deck of slides. That is his deck. So let's talk about Jefferson and the courts. And this is a big one. This is a huge one for U.S. history and our history today. Yes, this what I'm about to talk about really affects us today. It's Marbury versus Madison. So John Adams appoints justices for different courts. This guy Marbury was supposed to be a justice of the peace for the District of Columbia, and it's called midnight judges when you appoint these judges on your way out the door, as Adams did. What happens is Jefferson tells the Secretary of State, James Madison, don't give Marbury his appointment papers so he can't become a judge. Essentially, in our government, the Secretary of State handles a lot of paperwork, even though they're supposed to be the foreign secretary. They're supposed to be our foreign affairs leader. They wind up handling a lot of paperwork. In fact, when Richard Nixon resigned, who does the President of the United States write a letter of resignation to? The Secretary of State. Anyway, so Marbury sues, saying, Supreme Court, you have to force, under the Judiciary Act of 1789, you have to force Madison, Secretary of State, to give me my papers so I can take my spot as a judge. John Marshall, Chief Justice of the Supreme Court, writes the decision that he says that the Judiciary Act of 1789 was unconstitutional. Therefore, it's null and void. And guess what, Marbury? You don't get to become a judge. We don't care about Marbury so much as we care about this. 2 words, judicial review. Memorize them. Judicial review. Marbury versus Madison. You'll want to know that. You have to have that connection made. It is the precedent that the Supreme Court is the arbiter of whether or not a rule is constitutional. If a rule, a law, whether it be by the state government or the federal government, is not in compliance with the United States Constitution, the Supreme Court can strike it down and declare it null and void. That's a huge thing. To this day, the biggest Supreme Court cases as far as publicity have to do with constitutionality cases. Is a law, be it state or federal, constitutional? All right, so Hamilton and Burr, this is a nice, interesting story. So Aaron Burr, the real scoundrel vice president of Thomas Jefferson, gets into a dispute with Alexander Hamilton, and they're supposed to have a duel. Think about this time period. Dueling is quite common, but at the same time, it really is the hotheads that do this. You have Washington, Adams, John Adams, very, very passionate person, never was involved in a duel. So these two are really your people who really take it too far. Although it is suggested that this was supposed to be just an honor duel where they just shoot each other and say, hey, then our beef is squashed, not really intending to kill. But Burr shoots him right in the chest and kills him. There will be a president who does have a history of dueling coming up, but not yet in this unit. All right, anyway, Jefferson in Europe. So Jefferson is elected in 1804, and things go really well until he makes a really poor choice in the embargo of 1807. So American ships are being attacked by both the French and British because neither the French nor the British wants us trading with the opposites at the time of the Napoleonic Wars. And so Jefferson says, forget it. We're just going to have an embargo against trade with all foreign countries. And what happens is the effects of this on the European powers is minimal. The effects on traders and merchants in the United States is quite a lot, and it really causes Jefferson's popularity to decline, and it causes economic hardship. It's the embargo of 1807, really, really disastrous decision that did nothing to punish did nothing to punish the Europeans it was directed at. And so that's Jefferson, part 2. Thank you, Mr. Boyle, for making this deck of notes.